Hello everyone, a very warm welcome to all of you. I'm Siri Prasad. I'm an advocate and mediator from India. I'm pursuing my master's at the London School of Economics. I welcome you all to the panel discussion on the new era for foreign lawyers in India, hosted by Ashurst LLP in collaboration with Nehru Centre, the cultural wing of the High Commission of India to the UK. This would be an open and informative panel discussion on the new legal era for India. The new rules released in spring 2023 by the Bar Council of India enables international lawyers and arbitration practitioners to advise in India. India, a rapidly changing country, is aiming for a future where on a reciprocal basis, foreign lawyers and law firms will be able to practice in transactional and corporate work such as joint ventures, mergers and acquisitions, intellectual property matters, and much more. The aim of the discussion is to shine a light on the lessons learned so far and clarify the key questions which need to be answered for a competitive and workable roadmap ahead. The session will end with a question and answer session. It's my absolute honor to welcome all of you. Our first speaker is Alison Hook. She's the co-founder of Hook Tangaza, following the merger of Hook International and Tangaza Advisory Services in 2016. Alison leads on Hook Tangaza's technical assistance, trade and regulatory work. Before setting up Hook International in 2011, Alison was the director of International at the Law Society of England and Wales, where she played a leading role in advocating for more open legal markets and working with government to develop an export promotion strategy for UK legal services. Earlier in her career, Alison worked for the European Commission, both in London and Brussels, for the Foreign and Commonwealth Office. Our second speaker is Mikhail Lawrence. He's the head of International Law Society. Before his current position as head of our international department, Mikhail worked as head of the Law Society's office since 2012. He spent 9 years as policy manager in the international department of the Law Society of England and Wales in London, where he worked on international trade issues and the EU internal market and legal services. Our third speaker is Jeffrey Picton Tuberville. He's the consultant in the corporate practice at Ashurst LLP. Jeffrey specializes in work in the international energy and natural resources sector and has considerable experience of energy-related projects. In 1994, he opened the firm's license office in New Delhi, India, and was resident partner before returning to the UK in 1995. He has also worked extensively in the Middle East and North African region and was instrumental in the establishment of Ashurst's presence in the Middle East, initially in Dubai and also in Abu Dhabi. He was head of Ashurst's global energy team from 2004 to 2014. Our fourth speaker is Tony Williams. As the principal of Jomati Consultants, he advises on firm strategy and its implementation, including business planning and positioning of law firms in their market. He is also actively involved in firm strategic expansion, including mergers, new offices, alliances, and team hires. Before founding Jomati Consultants, Tony was worldwide managing partner of Anderson Legal and head of its UK practices. For his role in the orderly and controlled dissolution of Garrett's, he was named Partner of the Year by the Law magazine in 2002. Our final speaker is Mr. Kumar Subramani. Kumar is an England and Wales qualified solicitor, accredited mediator in the United Kingdom, and an advocate from India. He founded the firm KTS Legal in the year 2011 and is currently the managing director and partner in the firm. His areas of expertise are commercial and residential property, corporate and personal immigration, corporate law, commercial and civil litigation. Last but not the least, our moderator and the woman behind the show is Ms. Indrani Datta. She's a London-born non-practicing barrister and legal professional with an academic specialization in banking and finance. Her in-house counsel training took place in Linklaters, after which she was in the in-house counsel team for almost a decade at Clifford Chance. She's currently a senior advisor at Ashurst and continues to curate and present events and shows related to India. Indrani is also a trained classical Kathak dancer, teacher, and performance curator who over the last 20 years has devised commissioned work for institutions such as VNA, British Museum, Nehru Centre, Science Museum, and BBC Radio 4. I'm sure this discussion is going to be very, very fruitful, and over to you, Indrani.
Am I audible? Yes. Lovely. Thank you so much. What a wonderful, warm reception by the Nehru Centre. And huge thanks to Siri for making the beginning part so lovely and friendly. Friends, welcome. This is very much a home from home, and if you're here as a repeat friend or a new friend, you're both equally welcome. This is an open forum. Any of your views are most welcome. Be frank, be open, be generous, be kind. And I would like to start off with just a little précis of where we're at the moment. My memory is not the best, so I'm going to read it out. India's growth has been hard to miss. During the last few decades, the momentum around opening up India's legal sector has been rather a one-sided dance. Many foreign law firms vying and succeeding to set up best friend relationships with reputed Indian law firms, but not being permitted to practice in India. Till this year, India has kept her doors closed for foreign law firms to play a more equal counterpart role to law firms in India. Firms like Clifford Chance, for example, operate from their India office, employing Indian professionals for administrative work, working closely with Indian chosen law firms to service their Indian clients. So, against this background, we can see the degree of change for which India is now prepared for. I'd like to take a few moments just to go over the announcement that came in at midnight and was effective upon midnight. March 2023, Bar Council of India announced that its rules will permit for foreign law firms to practice foreign law and international law in India on the basis of reciprocity in limited situations. The clarifications soon after followed. What are they? Foreign law firms will be allowed to act on matters involving foreign law or international law. Foreign law firms would provide this advice on matters involving foreign law or international law for their foreign clients only. Foreign law firms would not be allowed to assist these clients in foreign law firms would be allowed to assist these clients in non-litigation areas only. Foreign lawyers will not be allowed to appear in any court or tribunal in India. Foreign lawyers would be allowed to appear for the clients in international commercial arbitration. And of course, the registration follows, valid for 5 years with 12 requirements. There's some key points in there. The applicant would have to pay the registration fee and a guarantee. They'd have to obtain a no objection certificate from the Ministry of Law and Justice in India. Some additional promises, such as following the ethics and rules of the BCI, and of course, reciprocity. And the conversation, there's a lot to speak about on this point. So, I would first like to actually open up to Alison and ask, because of Alison's vast experience in this particular field, on the key stakeholders. With any conversation, it's really important to know who's involved and who's playing what role. So Alison, who would you say at the moment are the key stakeholders and the dynamic perhaps between the government bodies and the legislative body, just so that we know where we stand?
What a question. Hello, everybody. Thank you very much for the invitation to be here today and to speak about this subject, which I have been talking about for about 20 years. On the question of key stakeholders, so obviously on the India side, we have the Bar Council of India. Now, the Bar Council of India has over the years taken many different views, had many different forms, but has hitherto been reluctant to nail its colours to the mast and actually come out and say we are open to the possibility of some kind of liberalisation. But in fact, we were talking, when I was at the Law Society, we were talking openly to the Bar Council, who had been instructed by the Ministry of Law in India to talk to the Law Society and the Bar Council here back in 2007. So those discussions have been going on for a very, very long time. The problem that we always had when discussing liberalisation is that there was always this impression that somehow or other there was this wall of foreign lawyers who were pushing to get into India, Whereas in fact, although that was, there were foreign law firms that were very interested in entering the Indian market, obviously they did back in the 90s. That was largely driven by clients who felt there weren't sufficient Indian law firms there at the time to be able to fulfill their needs. So that's where the impetus was coming, and the impetus came from clients, but it also came from the Indian government, because the Indian government at the time was one of the biggest clients of foreign law firms. So it was actually the Ministry of Law and Justice that was saying to us, the English side, back in the early 2000s, we want this to happen. So 20 years down the line, nearly 25 years down the line, we're still trying to get all the different players to align. Because on the government side, there were at least 3 different ministries that had different interests. Ministry of Commerce, Ministry of Finance, Ministry of Law and Justice. And getting all of the players to align, given that there's a lot of domestic politics involved as well, was always very difficult. Then getting the profession on the Indian side to share, to come up with a common view was impossible. And I think that's kind of where we are today, in that you had Indian law firms, big Indian law firms that have different interests. You had other representative groups within the profession, some of which had a slightly more representative role than others, but equally, one would be satisfied and the next would not. And then you have the Bar Council and you have state bar councils. Getting all of those players to align has been a dance over these 25 years where nothing has ever fully aligned, and we're not there yet. But perhaps there are more players aligned. Sorry, it's a bit of a long-winded response.
No, that's a very, very good setting of the scene, because now we understand that the conversation is in parts, parallel conversations are happening, and there are some who now want to play together, and it might be that we are closer to the goal and to that vision that we were speaking about 30 years ago, when I hadn't even thought about studying law. So,
if I can, because I think the most important thing to get out of that is that from the outside, sometimes it can look like this is a demand that is coming from outside. It's not. It's actually, and interestingly, when I was looking at Manmohan Singh's 1991 budget speech, which is kind of where it all began. And there's a phrase that he used in that, which was, as Victor Hugo once said, "No power on earth can stop an idea whose time has come." And he was talking more about India as an economic power. Yes, you cannot stop it, but you can slow it down quite a lot. And so that's what we're still waiting for.
Absolutely, yeah. And just to talk about numbers a little bit, I think we were looking at circa 121 deals in 2022, which translated to $9 billion. In terms of ease of doing business, India's moved from 143 to 163 out of 190 nations. So my point is, if something wants to be done in India and India wants it done, it gets done. So question is, where are the sticking points, where are the touch points here that are adding friction to the momentum? Mikhail, you are now obviously very much in the driving seat at the Law Society as head of international, and involved in those current conversations and involved in the latest thoughts. How does the 30 years that we're talking about sit in relation to what you are now witnessing?
Sure, thank you, and good seeing so many of you tonight to discuss this issue as well. So yeah, I've been involved only in the latest phase of this long journey, probably for the past 5 years, but impacted by the pandemic. We've been engaged with the Bar Council of India, as well as with the Ministry of Law and Justice, on this issue of foreign lawyers and foreign law firms in India. I think to add to the picture, I would say that a lot of India-related legal work today takes place outside of India, takes place in Singapore, takes place in Dubai, takes place in London. Also, to add to the picture, we're not, as foreign lawyers, foreign law firms, you know, the interest is not to do Indian court work. You know, it's about, you know, high value international transactional work. Obviously, you know, international arbitration, you know, is part of the picture as well, but it's not about doing litigation in Indian courts. And so for the Indian government, I think the issue is like, as they have, you know, strong ambitions to develop Indian economy, you know, currently the 5th largest economy in the world, with the ambition to become the 3rd largest economy, you need to address this issue of all this legal work being done outside of India. And I think that's where we are at the moment. So we have been engaged in discussions with the Indian government, with the Bar Council of India. The relations are really good at the moment, really positive. We were in India in February, March. Actually, we met with the Bar Council of India, I think the day before they published the regulations. And even though that came as a real surprise to us and to, I think, most stakeholders in India, and we continue the dialogue you know, because the regulations, I think what's significant with the regulation is like you have an acknowledgement from the Bar Council of India that now is the time to discuss the issue of foreign lawyers, foreign law firms in India. And obviously, you know, so far there had been more on the opposing side of the argument, you know, involved in the Balaji case. I'm sure we'll discuss that at the Supreme Court and so on. And now there's recognition that, you know, now is the time to discuss that. It's true that not all the stakeholders are aligned. I mean, we've got a strong stakeholder in the Society of Indian Law Firms and some of the top Indian law firms, you know, very sophisticated law firms, but still trying to slow down or to resist, you know, that eventuality of potentially having foreign law firms opening up in India. Having said that, you know, the regulations, yes, they are published, but there's still so many questions to be answered about them, and I'm sure we'll go into further details.
Absolutely.
I mean, you know, flying out, you know, the assessment of reciprocity, the issue of joint practice. What advice you can give to clients? You know, if you're only able to be in India to advise foreign clients, why would you want to be in India? You do it from London, from Singapore, from Dubai. So I think all these issues require clarification. And so we will continue engaging with the Bar Council of India. We've sent them our comments and questions on the regulations. We're going back to Delhi in September to continue the dialogue. They're organizing a big international conference and we'll be attending there, and we'll be going back in November. We're also hoping that the Ministry of Law and Justice will come to London by the end of the summer or in the autumn to discuss this further. Just one last thing, obviously it's within the context of FTA negotiations between the UK and India. Legal services was a key interest from the UK side. Obviously the publication of the regulations came, you know, independently of this negotiation. And what's interesting in terms of the dynamics of this negotiation is that legal services is not the taboo it used to be anymore.
Absolutely. And I mean, you can't miss the fact that the FTA is pending, well, it missed its deadline in October 2022, and that's something that's very much at the forefront of the stakeholders' minds probably. And not just the UK, but I think the FTAs with Australia are also pending. You mentioned the Balaji's case. Just for our audience here, I just wanted to quickly review that so that we're in the right place in the conversation. So in 2018, Supreme Court judgment in Balaji's case is where the petitioner was the Bar Council of India, challenging the Madras High Court, who ruled that foreign lawyers could assist in India on a fly-in, fly-out basis and periodically help on arbitration matters. So essentially what you kind of call casual. So it wouldn't count as practicing in law. And this was the Bar Council challenged and the Supreme Court held only Indian citizens could practice law. And this is the key word, practice. It meant any kind of legal work. And this is a really great point at which I'd like to bring in Jeffrey, my mentor, because we were talking about this 30-year landmark, and next year will be a very key 30-year landmark. And I want to take us back to 1994 because there's a very interesting story that Jeffrey has, a personal story that he can share with us, which really, really tells us what being on the ground was like. So Jeffrey, over to you.
Thanks, Indy. And as colleagues have said, it's a great pleasure to be here and to share some thoughts with you all. And yes, it is 29 years since I was asked by Ashurst, as a fresh-faced young partner, look what's happened to me since, to go out to open Ashurst's liaison office in Delhi. And little did I know, actually, at the time, that I was stepping into a contentious issue which would still be unresolved to this day. Of course, much has changed since then in every respect, but the announcement by the BCI is the biggest single step forward in the liberalisation of the legal sector since back in the mid-90s. And I think, as Mikhail said, while there's much work to be done and there are many, many issues to be clarified and developed, there is also, with this, much cause for optimism as well, that we are moving in the right direction towards a basis that will work for both the Indian legal fraternity and foreign law firms who want to practice there. I would actually, before getting into the story a bit, like to pay tribute not only to the work of the BCI, but also to the tireless efforts of Mikhail and his colleagues and Alison and her colleagues before that over the years, because it's not always been easy, I think, and there has been tremendous progress made, and I know that they are continuing to work on behalf of us all to get to the point where foreign law firms can operate in India on a mutually acceptable basis. So it has been a tremendous effort to move to this point. The history is important and, of course, informs where we are today, and there are lots of lessons one can learn. So I'll sort of go through very quickly the story. We were at Ashurst, or Ashurst Morris Crisp as it was in those days, granted permission in 1994 by the Reserve Bank of India to open a liaison office in Delhi. I was a brand new partner. It was a fascinating, challenging time and a wonderful experience to live in India. And we made many friends, many of whom remain very good friends today. The rationale, as Alison has said at the time, was very much client-driven. India was opening up its economy, having been a closed economy for many years. It was liberalising, it was inviting foreign investment on a large scale, and particularly in the energy sector, with US, UK, German and other energy companies coming in to build new power stations and that sort of thing, as well as a lot of foreign investment in other sectors. There were two other foreign firms already there when we set up, Chapbourne Park and White and Case, and they had also set up liaison offices. And the liaison office was a vehicle that was available under the foreign investment laws in India to organizations who were looking to establish a foothold. It had a very limited scope, like a sort of rep office, where you could act as a rep on the ground but not do substantive work. So it was actually quite limited in what one could do. And we were advised by one of the leading Delhi law firms as to how to do this and to how to set it up. And interestingly, I do remember that they said that we should start with the liaison office, and we would probably, if all went well, be able to convert it into a fully operating branch office within a year or so. So here we are, 29 years later. But we continue to hope. It quite quickly became apparent that there was a groundswell of opposition among some parts of the legal sector. And to be honest, with hindsight, I realise now that was not surprising. You know, the practice of law was the preserve of people who were registered under the Advocates Act. So if you think about it, suddenly to see some foreign law firms coming in and setting up liaison offices, what were they doing? What were they up to, and so on. So I think it wasn't surprising that that it provoked that that opposition, and I think there was probably a perception that foreign law firms were trying to circumvent the provisions of the Advocates Act by going through a liaison office, which was actually not the case at all and not the intention at all. As Indy has said, it ended up in the Bombay High Court in 1995, the claim by the Lawyers Collective against a whole raft of Indian authorities, including the Union Government, the Reserve Bank of India, the Bar Councils, and the 3 foreign firms. And the 2 issues were quite interesting issues. The first one was whether the permissions granted by the Reserve Bank were valid in the first place and legal. And the second one was, if they were validly granted, were the foreign law firms, quotes, practicing the profession of law, unquotes, by being there and having the liaison offices. And there was a question as to whether the profession of law meant just court work or was much wider. And as Indy's mentioned, that was resolved through these court hearings. The case was actually finally heard and determined in 2009. And in the intervening years, Chadbourne's and White and Case scaled back their operations and eventually closed their offices. We kept ours open, not without difficulty. We were regularly inspected. Inspected is probably a polite way of putting it, by the Reserve Bank officials who would arrive, at crack of dawn and demand to go through all the files and so on. And the license was renewed on an annual basis, provided they were satisfied that we were compliant. And so we kept the office open until the case was heard in 2009, when the Chief Justice of the Bombay High Court held that, first of all, the permissions granted by the Reserve Bank were not, should not have been granted and were not lawful or not legal. And secondly, that the practice of law covers both litigious and non-litigious work, and that by operating through the liaison offices, the foreign law firms were effectively breaching the provisions of the Advocates Act. One could agree or disagree with that. If we were practicing law, I would say we were practicing singularly unsuccessfully, because we were operating a liaison office and we weren't carrying out any legal work. But that's where it ended up. And we took the view that, in fact, we could have taken it further, we could have taken it to the Supreme Court, but we took the view that actually the liaison office had sort of served its purpose, and we then went down the road of setting up a best friends arrangement with an Indian law firm, which we put in place in about 2009, 2010, I think. That sort of arrangement that's already been referred to, which we've had ever since, and we work very closely with them on a non-exclusive basis, and we've worked on many matters and transactions successfully together. And that's the way that most international law firms have gone in India, with some sort of tie-up with a local law firm. Indy's mentioned the subsequent case, which was in the Madras High Court and then was appealed to the Supreme Court. And that really is the history and brings us to where we are today, 29 years on, and with the BCI rules having now been published. But I think it's very clear to me that India's now very ready for liberalisation, and it's got many outstanding law firms and outstanding lawyers, and there's huge potential for growth and all the conditions for a vibrant, dynamic and thriving legal market. And I think if I could just say one other thing, India, I think the lesson that, if I could draw a lesson from the experience in 1994, is that it is absolutely critical, if this is to go forward and work successfully, that the basis on which foreign law firms can operate is clear and well understood. Because one of the problems that we had in 1994 was that there was a serious lack of clarity as to what you could do with liaison office, what you couldn't do. And you could go to 3 or 4 different Indian law firms and you would get different advice because it was a question of interpretation. And as Mikhail has said, there are many, many grey areas in these regulations. And I think for foreign law firms to confidently to be able to invest and put people on the ground on the basis of this, it's vital that there is clarity as to how it will actually work in practice, what people can do on the ground, what they can't do, and so on.
Absolutely. And anyone who's interested in this topic would have seen the various practice notes that have come out in the last few months. And some are actually very, very informative and helpful to understand when the devil is always in the detail, and when you look and see what truly does reciprocity mean, what would be the ethics that would be applicable. And there's a whole host of questions which have different varying shades of greyness in there. So I think what would be quite good is, from my perspective, because I sit here very much with my student hat on, this is a conversation which to me has a sense of freshness. I don't see it with 30 years of waiting period, but when I read the history, I feel the weight of the history. So, and also when I sit on this stage with over a century of legal experience on both my sides, I then realize that it isn't because of a lack of information or expertise or intelligence that we didn't get to where we wanted to 30 years ago. There's something else at play here. So I think what is really at the forefront of my mind now, and I would like to ask Tony, is, Tony, you've seen the whole gamut of things. You've been at Clifford Chance for 20 years, headed the firm up as its managing partner. It's been 20 years since you've left, and you've done huge amounts of work in the mergers field and giving advice on making businesses dynamic and international and successful. With that background of experience, how do you think India is doing in terms of its ease of business as a sort of national target? How do you see it? Because you're both an insider and an outsider.
So, good question, and thanks very much for inviting me along. I think it's an interesting one, because I'm always frustrated, and Alison mentioned it at the very beginning, that this is seen as some sort of attack on the Indian legal profession by foreign firms. I mean, if you look at the history, and we can see it now over 30-odd years of liberalisation in other regimes in the world, the big winners on that liberalisation have been the local pass. You look at that in China, you look at that in Singapore in particular. They have both benefited fantastically from that, and to such an extent that otherwise closed countries such as Saudi have now announced a series of major reforms to encourage more foreign law firms to come in, because they've recognised it helps to develop their profession. And the range of the Indian diaspora represented here this evening shows the range of very able lawyers qualified in a number of jurisdictions now, who would love to be able to find a way to work effectively in an international stage. And as Mikhail said, I think one of the disappointing things is a large part of that work, whether it's the litigious or the transactional, is no longer done in India. And that cannot be good for India PLC, let alone anything else. Coming to your point, I think India is a market that I think a lot of investors and others have seen as a fantastic market. It's a growing population. There's high level of education. There's growth. There's a level of dynamism. But I think there's also a level of skepticism. I think India has made it very difficult for foreign businesses to operate. The bureaucracy at both national and local level is labyrinthine, to say the least. And a number of major investors over the years have just thrown their hands up and given up. And so as a result, in a competitive world, I mean, you know, India's a very important economy. A lot of major businesses want to be there. But in a competitive world, they eventually say, am I going to wait 5, 10, 15 years to set up there? Or am I going to do a deal in these 3 other places around the world? Because there is competition on these sorts of things. And I know India is a very important market, but it can't forget that. And I think, you know, that's been one of the things that Singapore did 20 years ago. He said, we are a very small country. You know, they don't have the advantages that India has. We are a very small country, so therefore we're going to make ourselves count. We are going to be the professional services hub of the ASEAN. And we, as a government, are going to facilitate and nudge all of the bars and everywhere else to do it. So they set up SEAC, which is now one of the leading arbitration centres in the world, not just in the region. They had a regime for foreign law firms. They've done a range of things. I think I was told today there are now over 200 foreign law firms in Singapore, of just about every nationality you can imagine. So it's done fantastically well for Singapore PLC, and I think that's important. I mean, there are a number of challenges here. I mean, you know, Alison and Michael have mentioned, you know, the various different ministries. Is everybody rowing the right way or not? I mean, I, 25 years, not quite as long ago as Jeffrey, but 25 years ago, had a meeting with the then Indian Attorney General. And he said, Mr. Williams, just be patient. Foreign law firms will be allowed in India within 2 years. Unfortunately, what he didn't tell me is when the 2 years started, okay? So I think there's a level of frustration, and that's true, I think, if you talk about, across a range, not just in law, I think if you talk to a range of people in all sorts of businesses, they'll talk of that frustration. The other one that's been linked to that is an incomprehensible tax regime. The fact that even if you have a rep office or a small office, or if your lawyers in total spend more than 30 days a year in India, the Indian tax authorities can seek to claim a portion of your global revenues. If you wanted a reason for people not to come, I mean, it's really like holding a gun to your head. That level of uncertainty business is not going to face. And, you know, so I thought the Bar Council, I was really excited when I saw that. I thought, wow, this, you know, we've been waiting for it so long. There are a lot of other bits that are needed. I think if the Indian government and the various other stakeholders get aligned, it's a fantastic opportunity, not just for the legal sector in India and the foreign firms, but for India as an economy, because access to lawyers with good international experience, with a good range of skills, whatever, only helps develop a legal market.
Absolutely, especially because the outbound merger activity is up and up, and that gives impetus for India to make sure that socks are pulled up. I'm really glad that we have Kumar here, because he's someone who has 2 hats, because you're both an advocate and you're a solicitor, and you have experience, personal, hopefully recent experience, and also talking to your contemporaries in India, of what the consensus is like over there, and in your view, what you would say the Indian profession is looking like at the moment. Because having spoken to a few of my friends in Mumbai, there's a real need to see some change internally within the profession. And I would like you to share your thoughts on that.
Thank you. Thank you very much. Yes, there is still a long way to go in terms of opening up the Indian market. I mean, there isn't a level playing field, as we say, and there is still family-controlled firms there, and and they still want to control the law firms in India. And in terms of level playing field, I mean, law firms in India are still not able to advertise the practice or have a website for themselves or market themselves. So there is a big block there in terms of putting the name out to attract clients. And in terms of raising capital as well, they are not able to do that from non-lawyers in India. That's another restriction. And in terms of number of partners that they can have in the law firm, I think it's limited to 20 numbers. So there are so many restrictions like that. And in terms of reciprocity as well, as Mikhail mentioned, why would a firm go to India if they can advise on foreign law in UK? There is a real problem there, and a law firm from UK can establish a practice in India, but they can't employ a local lawyer to advise on Indian law. So it has to be on a foreign law. That's another problem there. And in terms of qualifying in India as well, a law graduate from India can come here and they can qualify as a lawyer, a solicitor in UK, whereas you can't do that in India. So these are issues, I think, in terms of reciprocity as well. And there are issues with work permit as well, both ways.
Absolutely.
Yeah.
I'd like to talk about that because, if there are some physical barriers, I mean, the visa work permit issue is a real issue. If we're not just talking about foreign law firms, we're also talking about foreign lawyers, so individuals. And if they want ease of access into the Indian market, and this goes to the reciprocity point. If there is a law firm in India who are going to welcome a UK lawyer, and on the basis that the UK law firm will be opening arms to the Indian lawyer, but in reality, from what I've been hearing, is that getting the visas, getting the work permits to UK is not always a very easy matter, especially if you're talking about an individual lawyer. One of the things that I wanted to raise with you, Kumar, is that how important is the lobby in India? Because we've mentioned a couple of times. Alison mentioned SILF, which is the full name of SILF is Society of Indian Law Firms. So, listening to SILF, who've also submitted their comments to the BCI, it's a very telling. Position that they hold. They started off initially with just a few law firms, and then soon they had about 80 large law firms as members of SILF. Between 2000 and 2014, completely opposed to opening up. And then something started shifting about 10 years ago, and the conversation started becoming more tolerant. And now we can see sector-wide within the practitioning community in India, there is, generally speaking, support. It seems that they are ready for competition. They want to learn, they want to compete, they want to share information. So I think what I'm finding a bit interesting here is that the government were initially pushing it, and they still are, and they haven't, even though the BCI announcement came before the Ministry of Commerce were quite ready for it. That makes me smile, that if they are having conversations and one is announcing something, BCI report to the Ministry of Law of Justice, who's having conversations with Ministry of Commerce, but Ministry of Commerce don't know that this midnight announcement is going to come out. You kind of wonder, why aren't they all on the same WhatsApp? So I think my question to you is, having spoken to your contemporaries in India, are they for it or against it?
I have spoken to a few of my friends who are practicing Supreme Court. I think they are for it. They want to see competition. They want to see better provision of legal services to the customers. I think by bringing in the foreign competition, the service will improve. But there are small firms which are nervous about it because it's a fear of unknown. And I mean, if they know that the foreign firms are here only to do transactional and to serve the clients internationally, and they're not for any of the contentious court matters, I think they'll feel more comfortable. I think it's still unclear to them. Once they know the whole gamut of the new rules, I think they'll understand and they'll appreciate.
Absolutely. I had something interesting to read out here. It's from so one of the behind the scenes friends who've been helping is one of my family friends, partner at Kaitan in Mumbai. Again, a very well-known international and historic reputed law firm in India. And I was interested in this, in the fact that Indian law firms cannot advertise. So if they can't advertise, what can they do? So this is an example of something that's fairly inventive and allowed. And I wanted to read it out to you because I thought it would be interesting to see an example of telling people what you do but not telling them at the same time. The Bar Council of India does not permit advertisement or solicitation by advocates in any form or manner. By accessing this website, you acknowledge and confirm that you are seeking information relating to said firm of your own accord and that there has been no form of solicitation, advertisement, or inducement by the firm or its members. Its content, the content of this website is for informational purposes only and should not be interpreted as soliciting or advertisement. No material or information provided on this website should be construed as legal advice. The firm shall not be liable for consequences of any action taken by relying on the material or information provided by this website. The contents of this website are the intellectual property of the firm.
Terms and conditions you would find on any legal website. It's just you have to look for them rather than click on the way through. Just to say that actually that used to be the case with all Indian law firm websites that you went